Hello, and today I'll be giving a short talk on civil liberties in the United States. Just a side note, this video lecture is merely intended to complement your reading of the chapter in the textbook. So you will have to read the chapter yourselves. Can we trust our government to do what's right all the time? Is the government always doing what uh, it thinks is right and best for the people, for all of the people? These questions were on the minds of the founding fathers of the United States as they were writing up their constitution back in the late 18th century. This is the reason why the US Constitution protects the rights of people to free speech, to free assembly, uh, exercise of religion, and privacy, among others, as a means to defend the civil liberties of Americans. As we will see, civil liberties have deep roots in the United States to the extent that outsiders might even find it strange or even unacceptable. Let's first define what we mean by civil liberties and how we can distinguish civil liberties from civil rights. Uh, as you know, we're going to have a separate discussion on civil rights later on. But what's the difference between civil liberties and civil rights? Both are often seen in the context of protecting certain rights of individuals and groups and the people. This is the reason why many Americans use civil liberties and civil rights kind of interchangeably. Civil liberties are meant to protect the individual from improper or tyrannical government action. Civil liberties impose limits on government actions uh, that limit the freedoms enjoyed by people. Civil rights, on the other hand, which is a subject that we will take up in another chapter, as I said, are the limits on the powers enjoyed by majorities to make decisions that would benefit some but at the expense of others. So, civil rights enforce the principles of equality and non discrimination. Civil liberties are what government must not do to encroach upon the rights or liberties or freedoms of individuals, while civil rights are basically phrased more positively. This is what government must do to ensure equal citizenship and protection from discrimination. An example of a civil liberty is the right to free assembly and organization, and this right is considered an individual's inherent right that cannot be taken away from him and cannot be curtailed, certainly by any kind of government. Um, an example of a civil right, on the other hand, is the right to vote. Government must make sure that this right to vote is equally applied to all citizens. To impose preconditions to voting like gender or sex or race or religion would be a violation of the civil rights principle of equality and non-discrimination. The civil liberties of Americans are enshrined and enumerated specifically in the Bill of Rights of the United States Constitution. The Bill of Rights is actually the first 10 amendments to the US Constitution of 1789. As you know, as of now, there are 27 amendments to the US Constitution. Now, let's remember that when the framers of the Constitution of the United States were drafting their charter, um, this was in the spring, or rather spring or summer of 1787. The delegates from the 13 states at the time didn't give much thought to having a Bill of Rights incorporated into their national constitution, partly because their respective state constitutions already guaranteed these rights and liberties, but also partly because I think the delegates were not thinking straight at the time, because remember, this was already summertime, before air conditioning, before iced coffee, and so the place that they were holding their convention was not very comfortable, to say the least. And the heated discussions added also to the temperature, in the room at the time. And so, what exactly are these 10 amendments? I won't be taking them up uh, in detail, all 10 amendments specifically. Instead, what I'll do is sort of sum up, you know, key parts of it, starting with, of course, the First Amendment. First Amendment directs Congress uh, and pertains to uh, directs Congress not to pass any kind of law, that would uh, interfere in the principles of freedom of worship, free expression, and free assembly. Requiring prayers to be said in public schools. No? We're talking about schools that are funded by governments, no? By the state or national government. Um, it's considered a violation of the First Amendment. But private schools, of course, definitely can institute their own system, including saying of prayers. But public schools, government institutions, should not impose any kind of religious belief or practice or sentiment, and certain prayers are considered an expression of one's religious beliefs or affiliation. So it doesn't have a place in the Constitution. Um, Freedom of speech, on on the other hand, does have certain limits, particularly when it moves towards action, or what is considered by many Americans to be fighting words, or speech that incites damaging conduct, destructive conduct. Well, what constitutes fighting words? Okay, up to the 1950s, fighting words meant insulting words, like calling someone a fascist. In recent years, however, fighting words have been applied more and more to words seen as offensive or slurs against members of a particular group, like women or persons of color or ethnicity, like Jews. The second, third, and fourth amendments. Okay, I'm sorry if the text in this slide is small. No, the next slide actually will show even smaller text, but you have to read the amendments yourselves, the full amendments yourselves. No? But in any case, the second, third, and fourth amendments are implicitly directed at all branches of the national government, and they specify the limits imposed upon that government that would infringe on the individual's rights to bear arms, housing or quartering soldiers without the owner's consent, and the right against search and seizure. Now, I speak here of the right to bear arms, no, the right to bear arms, not as having the right to bear arms, no, literally, but I'm actually referring to the right of a person to carry weapons outside of or independent of serving in the military or the armed forces. Um, Imposing restrictions or limits on gun ownership, like you have to pass a psychological evaluation, or you have to have a drug test or something like that, can be seen as violations of the Second Amendment. Okay? However, the right to bear arms outside of official military service is a contentious issue. Um, there's no definitive position at least, insofar as many Americans are concerned, especially since the country has experienced numerous instances of mass shootings taking place, particularly in schools in different parts of the United States. So there are Americans who insist, that this Second Amendment right uh, is universal, rather inherent, and should be protected at all costs. While there are also many Americans who say that this right requires certain caps or limits to it. In other cases, even requiring what are called trigger locks, okay, or putting them in safes uh, within a person's privately owned residence can be considered even a violation of the Second Amendment. This is why, as you will probably notice in many on TV, when you watch reality shows of American homes, they would usually have their guns, their long firearms, shotguns, and other firearms on display, in their living rooms, because it's their inherent right to own guns, to bear arms. Okay. Illegal seizures and searches are also a constant issue or problem in the United States, especially when it comes to profiling, for example, people of color or people who look Muslim, but it's altogether is seen as an inherent right protected by the Bill of Rights of the U.S. Constitution. Um, okay. Now, the Fifth, Sixth, and Eighth Amendments. Again, I'm sorry for showing you these small texts, but you can read these amendments yourselves in greater detail in the textbook, or you can search online for those amendments yourselves. These amendments are directed at the courts and pertain to the conduct of the courts and the due process of law. Okay. The right against self-incrimination and freedom from torture are rights that pertain also to these amendments. Certain forms of capital punishment like beheading or hanging or electrocution have been seen as forms of cruel and unusual punishment. The Constitution does not really prohibit the death penalty. What it prohibits is cruel and unusual punishment. Okay? So the manner of capital punishment, the manner of inflicting the death penalty, can also be problematic. In certain instances, also, even conditions in the prisons have been connected to the cruel and unusual punishment provision of the Bill of Rights. Okay. Then we have the Ninth and 10th Amendments. Okay. As you can see there, they're quite short and refer to at least a couple of things. No? The Ninth and Tenth Amendments refer to the retained rights that are not enumerated and are reserved uh, in the states or to the people directly. Okay? The U.S. Constitution was drafted, as you know, in the 18th century, a particular time. However, the framers were also mindful that times change. Okay, so to anticipate changes over time, what they did was to come up with the Ninth and Tenth Amendments that allowed the people to retain their inherent rights even before they were defined. Okay, before they could be defined. Uh, so there are going to be rights and situations that will arise that certainly no constitution can anticipate. And so, with the Ninth Amendment in particular, no, such changes can now be accommodated into the Bill of Rights. So, basically, what these two amendments are saying is that rights that have yet to be enumerated, unenumerated rights, are retained by the people. Just because the Constitution doesn't specifically mention a particular right, for example, the right to privacy or sexual orientation or something like that, doesn't mean that the people do not retain that right anymore. You know? Roe versus Wade, for example, established a woman's right to seek an abortion up to the 27th week of pregnancy, and this is protected by the unenumerated rights provision of the Bill of Rights. The 10th Amendment specifies that powers that are not granted to the national government, okay, are reserved or retained by the states or the people by and large. So what you have here is a Bill of Rights really that seeks to guarantee the rights and liberties and freedoms of the people, regardless of the situation prevailing. Now, next question is, I mean, at least there is a question in your textbook regarding the effective coverage of the Bill of Rights. Which government, which level of government, for example, is the Bill of Rights directed? Are these governmental limits applicable to both the national and state governments or only to the national government and its branches? The Bill of Rights doesn't actually explicitly state that all the 10 amendments, all the Bill of Rights apply to the national government alone or both to the national and state governments. The only time that the national government is actually referred to is in the first provision. Congress shall make no law, etc., etc. And this is only specific to one branch, no, of government, Congress. But of course, the implicit direction of the Bill of Rights is towards government in general. That includes three branches. But there is a question mark there as to what level of government the Bill of Rights should apply to. In the beginning, the Bill of Rights applied only or was seen as applicable only to the national government and its branches. So states were exempted basically because they retained their powers to determine their own laws. No? Aside from that, as I mentioned earlier, the state governments were already limited by the respective state constitutions and judiciaries. Okay, and then in 1868, something happened. The 14th Amendment was introduced and passed, which provided that, as you can see there, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state uh, deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay? So this refers specifically to states, state governments. Now, you have what you have is both federal and state governments are in the same boat. Both, both are expected now to follow the same Bill of Rights. Okay? The extension or the incorporation of the Bill of Rights into the state governments didn't happen, overnight. Okay, it took a considerable amount of time before the states incorporated all the first 10 amendments. By the 60s, almost all the provisions of the Bill of Rights, all 10 amendments, were incorporated and applied to the states by the 14th Amendment. As we've seen, civil liberties are a prominent and deeply embedded and institutionalized feature of the American political system. The Bill of Rights represents a key defense against arbitrary and tyrannical government and seeks to impose, or rather institute, these liberties and enshrine these liberties in the people. American civil liberties may be abused from time to time, perhaps, no? And circumvented by, for example, one so-called Trump. But these liberties cannot be easily glossed over or replaced or subverted by a populist leader, because they are deeply embedded and enshrined in the American political system and in American society. So this is all for now on civil liberties in the US. Thank you very much.